Welcome. Welcome, welcome, welcome. I'm Dean Martha Minow, and it is with enormous pleasure that I welcome everyone here to mark the award of the highest honor that the Harvard Law School can bestow upon a faculty member. I wanted to say family member, but it's both, which is the award of a chaired professorship. It is some measure of the specialness of this day that this is actually David Wilkins' second time in this position. In David's case, the chaired Lester Kissel Professorship of Law may offer places to stand and climb because he certainly doesn't spend much time sitting. We're honored today to have the presence of members of David's family. They include David's mother, Elizabeth Wilkins, David's son, Brian Wilkins, David's brother and sister, Timothy and Carolyn, cousins Joanne, Urs, brother-in-law John, niece Susan, and our distinguished and fabulous alum, Anne-Marie Wilkins, who happens to be married to David. We're all thrilled that you can be here today. The match between David Wilkins and the Lester Kissel Professorship is really quite extraordinary. It is the gift of Lester Kissel, who graduated from this law school in 1931 and who identified ethical and moral issues as his special concern long before he passed away in the year 2000 at the age of, are you ready, 96. Mr. Kissel worked at the New York firm of Sherman and Sterling, and then two of his own firms, Cornyn, Kissel, and Roseborough, and then Meyer, Kidder, Matz, and Kissel. He was a litigator. He was a business manager. He was an investor. Indeed, for many years, he was managing partner of a private investment firm while also being at a law firm. Is this a preview of David Wilkins living two lives at once? Three dimensions, in fact, of the Kissel chair make it so appropriate for David. First, Mr. Kissel was fascinated with India. He traveled annually there. He studied Hindu philosophy there. And as many of you know, David Wilkins gave the keynote address at the launch of the Jindal Global Law School there under the leadership of our graduate, Raj Kumar. By all accounts, and I have good ones, David's address was inspiring and brilliant, and he was mobbed like a rock star. Secondly, Mr. Kissel loved wine, and he assembled quite the collection. Need I say more? Third, Mr. Kissel explained that he established a professorship in ethics here, quote, reflecting my abiding concern for the critical importance of ethical practice in the profession. He continued, it is my hope that the Kissel professor, while not restricted solely to the teaching of legal ethics, could serve to advise and counsel the dean and the faculty on the most appropriate and effective methods of instilling into law students the ethical principles upon which the practice of law best serves the lawyer's clients in particular and society at large. Who could he have been thinking about except David Wilkins? David invented the country's first 4-credit course on the legal profession, and it remains one of the most sought-after courses in the curriculum. His seminars on the legal education for the 21st century, global perspective on preparing lawyers for global careers, cause lawyers, and the futures of the large law firm are cutting edge, fascinating, and memorable. His section of the first-year problem-solving course last year introduced students to remarkable perspectives on the lives and careers of lawyers and maybe kept them in class some extra hours. Professor Wilkins created and directs the program on the legal profession and the Center on Lawyers and Professional Service Industry, and he continues to do amazing things in both of those contexts. He's also the Senior Research Fellow of the American Bar Foundation, Faculty Associate of the Harvard University Edmund J. Safra Foundation Center for Ethics, and he and Andy Kaufman edit the landmark casebook, Problems in Professional Responsibility for a Changing Profession, which addresses every possible issue with zest and detail. David's own prolific scholarship opens so much new territory in research about the profession that it propels and lifts the entire field. I'll mention just 4 avenues in his work. The first examines the organizational and economic context, producing what he calls the ethical infrastructure of law practice. Here, his effort to map current practice and to generate empirical research moves the field from imagining ethics to be solely within the control of each individual to instead understanding the impact of organizational structure and pressures. Second, he's been a tireless leader in efforts to document and investigate the career paths of lawyers over time. He participates as a principal researcher in the massive After the JD study, a 10-year nationwide longitudinal study, the Harvard Law School Career Study, and his own unbelievably large undertaking involving over 200 in-depth interviews studying the history of African American lawyers. This points towards his third pioneering field, the study of diversity in the profession, with deep explorations of identity in the law, racial identity, gender, and increasingly nationality. Finally, David's work on how corporations purchase legal services and the offshoring of legal work by American law firms represents his foresight in examining global and economic transformations of the legal profession and professional services generally. This morning, I received word that the Fellows of the American Bar Foundation have selected David Wilkins for the honor of Distinguished Scholar Award for 2010. With this superb honor, David joins a select group of honorees that include Larry Tribe, Judge Richard Posner, Judge Guido Calabresi, Justice Ruth Bader Ginsburg, Paul Freund, and Deed Irwin Griswold. I went and looked at the ages that each person was when they got their award, and David is by far the youngest. Last year, I asked David to become the school's first vice dean for global initiatives on the legal profession. His indispensable guidance there introduces ideas of cradle-to-grave legal education, that's his phrase, education outside the classroom, work on admissions, recruitment, career advising and placement, executive education for leading lawyers from around the world. Just last week, as many of you know, David hosted the phenomenal conference here entitled Future Ed 2, Making Global Lawyers, Legal Education, Legal Practice, and the Paradox of Professional Distinctiveness, part of a multi-year effort with the New York Law School and other collaborators, with participants attending from India, China, Israel, Brazil, the American Bar Foundation, worlds of medicine and business, as well as people of many generations. I think, David, you did this so you wouldn't be preoccupied with the chair lecture, is that right? I am proud to say that I knew David when, or at least some time ago. And while much was expected of you, David, your superb career exceeds your extraordinary promise. David's a graduate of Harvard College, a graduate of Harvard Law School. He served on the Harvard Law Review. He served on the Harvard Civil Rights Civil Liberties Law Review. He clerked for Justice Thurgood Marshall. He clerked for Judge Wilfred Feinberg. He practiced at Nussbaum, Owen, and Webster. He specialized in civil litigation. He became the Kirkland and Ellis Professor before now becoming the Lester Kissel Professor. He is a much sought-after speaker around the world in academic institutions, conferences, bar associations. When he spoke recently to the ABA House of Delegates, it was reported, and I quote, "Harvard Law prof attempts to scare the bejesus out of the ABA." David may scare us. He will certainly edify us today with his lecture entitled Making Global Lawyers, Legal Education, Legal Practice, and the Paradox of Professional Distinctiveness. David is a dynamic and dazzling speaker and a shining member of our faculty. And when I say dazzling and shining, I'm not just talking about the snazzy suits. Please join me in welcoming the Lester Kissel Professor, David Wilkins.
Thank you very much. You know, usually when I hear an introduction like this, I say to myself, I usually say to the audience, you know, I just wish my mother were here to hear this. But she is here to hear this. So for that, Martha, I am very, very grateful. Thank you. I also want to thank the rest of my family is here. As you see, I've packed the room. This actually, I wasn't even going to tell this story, but this is actually the second time I did this because when I actually interviewed for a job here in 1995, I think, as Martha will remember, I was the only person ever to have my relatives in the room when I gave the job talk. And as Jim Thornburg said, that, you know, when somebody would ask a question, my brothers, one of whom was here, would glower at them. So needless to say, I figured it was an effective strategy. But I certainly want to thank my brother Timothy, my sister Carolyn and her family, my cousin Joanne and her family, and most particularly my wife Anne Marie and my son Brian, who have spent many nights and weekends watching me work and become increasingly anxious about a whole range of things, and who haven't endured, particularly lately, my excessive international travel. So I am deeply grateful to them, and without them I wouldn't be here, particularly Brian, who, when he asked me, "Is this going to be boring?" I had to say yes. And he still came. I also want to thank my prior deans, Elena Kagan and Bob Clark and Jim Thornburg, all of whom played a key role in my having the opportunity to be here today. Elena was tireless in her support of the program and really helped us launch the executive education program here, which has become so very successful. Bob was the person who awarded me my first chair from Kirkland & Ellis, and I want to recognize here the generosity of that firm in that wonderful contribution to my life and to the law firm. But Bob was also the person in 1996 who said, when I said we should have at least one full-time person working on the legal profession, he said, "You're right." And he gave me the freedom to pursue the kinds of things that Martha talked about. And finally, if it weren't for Jim Thornburg, I mean, I could talk about him for the rest of the time. If it wasn't for Jim Thornburg, I'd be much more likely to be in the population I study than to be the person studying it, meaning he was the person that got me into law practice. I also want to thank my colleagues at the program on the legal profession. Many of them are here today: John Coates and Ashish Nanda and Eric Ramanathan and Hakeem Lakhdar, as well as our terrific research fellows and support staff. Many, in fact, all of the accomplishments you heard about would not have been possible without their tireless efforts, and that was certainly on display for anybody who was around this weekend. I also want to thank my amazing assistant, Amanda Berry, who keeps me running even vaguely on time and is the only reason anybody can ever find me, as my colleague and co-author Andy Kaufman here knows. But I also finally want to thank Lester Kissel. I actually knew Lester Kissel. I actually, I'm not sure if this violates our conflict of interest policy, I actually helped solicit this chair. Dennis Thompson and I spent actually many evenings going down and talking to Lester about his interest in ethics for this law school and also for the Safra Center, where he also made a quite generous gift. And as I thought about Lester, who was really an amazing man and quite a character, and even then, when we were doing this was in the 90s, was already well up into his 80s, but sharp as a tack. But as I thought about Lester, in many ways he exemplified what I want to talk to you about today. Because as Martha said, he really was a product of the golden age of the legal profession. That era that now is sometimes looked back on quite nostalgically, in which Wall Street lawyers were sort of legends, in which law firms were still small and intimate partnerships, in which they were still the trusted advisors of their clients, in which mentorship and training and apprenticeship were very much the norm rather than the exception. He was very much a product of that golden age. But by the 1990s, when I was talking to him, that golden age was already beginning to fade. And in fact, that fading was very much exemplified by where we would meet. We would meet in his club, which was exactly what you would think, sort of wood paneling like this only everywhere. There was still a separate ladies' entrance and ladies' dining room, which was a recent innovation by the 1990s. In which the food was exactly the same as perhaps Paul Cravath would have dined on, and in fact may have been cooked around the time that Paul Cravath was eating. And even his beloved wines, which he had collected quite assiduously, all the kind of famous names of Bordeaux and Burgundy, but he had kept them around as sort of museum pieces, and by the time we went to drink them, they were all well past their prime. That was the world of the Wall Street law firm. But he was also an intensely curious person about the world. And as Martha said, he was interested in India. That understates it. He would trek to India for several months a year to study with his guru up in the mountains of the Himalayas. He was intensely curious and knowledgeable about Eastern philosophy. In fact, I think the reason Bob finally persuaded him to give the chair was that Bob himself knew a lot about Eastern philosophy, and that was very appealing to Lester Kissel. So within this very traditional man, this product of the Golden Age, was also this spark, this outward looking, this creativity, this interest in the world. It's that spark and hope that I want to talk to today. And I want to do it by thinking a little bit about what does it mean to make global lawyers today and what this means for our profession and for legal education. So I'm going to go through a bunch of stuff here. I'm going to go through it relatively quickly because I think a lot of it is actually familiar to many of you. So I guess I pointed this way. So here's the question everybody's asking right now, right? Are we entering some brave new world? Is the world of law practice being fundamentally reshaped, or is it just business as usual? Is this just a temporary blip? I went to a conference at Georgetown, which had the nice name of The Death of Big Law, right? Are we witnessing some fundamental paradigm shift? Or, as a law firm partner said to us last year at our executive education course, this is just a cycle, and it'll just go back to the way things were. It's not surprising that I'm going to say to you it's too early to tell. We don't know the answer to this question yet, and it's probably unlikely to be either. But what I do think it is that we're seeing big trends that had been going on long before the crash of 2008, that were accentuated by the crash, and that are likely to have important implications for everything we do. And I mean everything, not just the practices of elite lawyers, but the practice of all lawyers, not just here in the United States, but around the world. What are those big changes? These are familiar to all of you, right? The globalization of economic activity, the rise of information technology. As I'm feeling nostalgic here, I think my first job was in the, quote, computer room, where you had to like dress up in a white coat like you were going into surgery and wear like booties and gloves, and there were these giant machines with big tape drives going around spitting out perforated paper. I know the kids are looking like, what am I talking about? You know? And all of it, you know, has less computer probably than this thing that we all carry in our pockets, right? A huge transformation, as our friends in the Berkman Center have taught us. And finally, I think we all know that we're watching the disintegration, or at least blurring together, of the categories of knowledge that we have come to rely on at least since the 19th century and before, right? Those are the categories of the modern university, the various disciplines, you know, sociology, political science, economics, but they're also the professions themselves, which were created in the 19th century. That's when the modern legal profession, the modern medical profession gets going. And for our purposes, it's also the distinction between professions and business, between law and business, that we have come to accept. But it's also organizational forms, the modern corporation, the difference between corporations and partnerships and limited corporations, all of which are created in the 19th century, roughly speaking, all of which are blurring together in the 21st. What does this mean? Well, if you look around the economy, it's clear that you see a huge reduction in information asymmetry between buyers and sellers, which has allowed for the unbundling and repackaging of services along global supply chains. If you were in the business school or the Kennedy School, this is all anybody talks about in terms of what economic activity now looks like. We've seen a huge change in a world in which we measure things by inputs, like reputation and credentials, to one increasingly driven by value-added outputs. And finally, the unit of analysis of competition, of the economy, has moved from bounded firms, which are sealed off tightly from one another, to much more fluid networks. And Yochai Benkler and many other people have been doing terrific work on this here at Harvard Law School. This has already reshaped the legal profession in lots of ways. These are 5 categories I'm going to use, but you could use many others. I'll just sort of list them and then go back and say a few words about each one. So we've moved from a world of solo and very small firm practitioners to one of increasingly large professional organizations. We've moved from a world of homogeneity, where law was about as homogeneous as any profession or occupation in the world, to one of increasing diversity. We've moved from a world of incredibly limited competition in which there were only a few players who didn't compete very much with each other, to one of intense competition across global markets. We've moved from a profession governed almost exclusively by artisanal craft norms of our own creation to ones that are increasingly driven by profit maximization. And finally, we've moved from perhaps the most local of all businesses, in which, lawyers in Hamburg couldn't practice in Munich, or dare I say lawyers in Boston can't practice in Nashua, to one of increasing global reach. All right, so let me just say a few words about this. First, the institutionalization of legal practice. Look, it's important to recognize that many, in fact, most lawyers around the world continue to practice in ways that are very similar to the ways in which they practiced not just a generation ago, but a century ago. Even here in the United States, something like 40% of all lawyers today are in solo practice. And if you add on small firm practice, it gets up well over 50%. And that's increased, and that still is very true around the world. So we mentioned India. Mark Galander is part of a new project we're doing that's going to look at India. And he said to remind ourselves that the corporate sector of India maybe only has 5,000 lawyers in the large law firms, another 5,000 or 7,000 lawyers maybe inside corporations of various kinds, and that most of India's more than 1 million lawyers are practicing exactly the way they have been for at least 50 years, if not 100. Nevertheless, we have seen the rise of large law firms, first here in the United States and then in the UK, but increasingly around the world. Again, it's important to understand this is a very recent phenomenon. So Sherman & Sterling, a competitor to Lester Kissel's beloved Sullivan & Cromwell, was in 1965 the largest law firm in the world. It had 169 lawyers. As I like to say, that's now the Toledo branch of a Dayton law firm, okay? The largest law firms in the United States are now several thousand lawyers. Even if you take away Baker & McKinsey, which is a special case, we have more than 15 law firms that are over 1,000 lawyers. Several are over 2,000. Some are approaching 3,000, and mergers are happening every day. But the largest law firms in the world are not in the United States. They're in the UK. The UK Magic Circle firms, Linklaters, Freshfields, they often sound like grocery stores or potting goods stores, but in fact, Freshfields, as my brother is a partner of, that's why I'm teasing him, has about 2,500 lawyers, something like that, last you checked, in something like 25 countries around the world. And it's not just in the developed West. So in India, there are, Amarchand Mangalis has 400 lawyers. AZB Partners has 250 lawyers. In China, King & Wood has over 1,000 lawyers. Here's a hint. There's no Mr. King and there's no Mr. Wood. But there are 1,000 lawyers in this law firm, and it is not the only law firm of this size. There are large law firms in Korea. There are large law firms in Brazil. There are large law firms in almost every commercial center that one can imagine. But it's not just law firms. It's the growth of sophisticated in-house counsel. Quite frankly, in the United States, the fastest and most important growing sector of the bar for several years has been in-house counsel. There are now, the average size of the Fortune 500 legal department is approaching 100. Some of the largest are much larger. General Electric has 1,000 lawyers. Listen, 1,000 lawyers in its in-house legal department. But that's not just true here in the United States. It used to be in-house counsel was only a U.S. phenomenon. It's increasingly a global phenomenon. We had the general counsel of the Tata Group in our executive ed program on leadership and corporate counsel, and he told me they have 400 lawyers in the in-house legal department of the Tata Group in India. Increasingly, this is an important presence for lawyers. It's true on the public side. Dick Stewart, one of our former colleagues, once told me that when he was head of the lands division, I think in the Reagan administration, they had something like 50 lawyers. Now the environmental division of the Justice Department has several hundred lawyers. If you look at prosecutor's office, defender's offices, increasingly large organizational forms. And finally, we see the rise of legal clinics, of prepaid legal services as various forms of alliances in the individual sector, of online networks of lawyers. All of these things are likely to increase when the new regulatory reforms that are coming down the pike from the UK, which I'll talk about in a minute, go into effect. The point here is this. Increasingly, most lawyers are practicing in some form of organizational setting and increasingly of increasing scale. Second, it's not just a boys' club anymore. Law was traditionally the most restricted profession maybe in the world. Somebody once said, I think Willard Hurst once said, that prior to the 20th century, anybody could become a lawyer as long as you were a white, Anglo-Saxon, Protestant man of means. It was therefore open to talent. But this was true in many other places around the world. Whatever the cleavages were, whether it was about economic status or race or religion, law was an incredibly restricted profession. This is changing, and most notably with respect to women. Law is all over the world becoming an increasingly feminized profession, meaning a profession in which women dominate. Here in the United States, as all of you know, women are 50% of law students. We are, as we do in many things with respect to gender, we lag the rest of the world. In the UK, it's more like 57 or 58%. I lectured in Sweden, it's like 65%. In Brazil, it's closer to 70%. Law is becoming an increasingly a profession dominated by women. This will have profound implications for how we think about the legal profession, since the career path of law is not just a career path for men, it's a career path for a certain kind of a man, that is a man who has a wife who doesn't work. That is an increasing rarity all over the world in the world of legal practice. But it's not just gender. Issues of race, ethnicity, religious diversity. We know about these issues in the United States. It used to be, when I went to lecture on this subject, lecture about the legal profession in other places, no one thought about diversity. Now, everyone thinks about it. In fact, when I went to Sweden, they asked me to lecture at the bar, the Swedish bar, which I said I was very honored to do. I was there to do a lecture at the University of Stockholm. And I said, what do you want me to talk about? And they said, diversity. And I said, what is it, like the blondes versus the brunettes? What is the diversity in Sweden? But as I found out, there's tremendous diversity in Sweden because Sweden has had a very open immigration policy, particularly around political asylum. And I happened to meet a spectacular young man who's sitting in the audience now as one of our LLMs who was a refugee from Eritrea and has now become a leading lawyer in Sweden. And after we get through with him, he's going to run the whole place. But it's not just gender and religion, it's also other forms of diversity, disability, sexual orientation, and increasingly disciplinary diversity. I spoke about the UK reforms. We had the head of the UK Legal Services Board at our conference, and this time next year, it will be legal for lawyers and non-lawyers to practice together in the same organization. It will be legal for companies to own law firms, for law firms to float stock. So the range of people who will be working inside law firms and other similar institutions side by side is becoming increasingly diverse. The market for lawyers is changing dramatically too. We used to own the market for lawyers, and we did it in a way that suppressed competition. There were relatively few lawyers who competed in relatively bounded geographic areas, and frankly, with lots of policies that restricted competition. And the clients, even the corporate clients, were relatively unsophisticated. There was large information asymmetry between the producers and the buyers of legal services. We have moved to what some economists think of as a world of winner-take-all competition in which there is intense competition at every level for both clients and for lawyers. And we have not surprisingly seen the rise of market practices in which we have everything from CMOs, chief marketing officers, who are now routine in law firms. In fact, when Hogan and Hartson merged with the English firm Levels, they trumpeted the fact that they had the best CMO in the world because this has been a person who'd been a CMO at 3 other law firms beforehand. To mergers and acquisitions among law firms. My colleague John Coates is doing terrific work about thinking about applying his expertise in M&A to the increasing mergers and acquisitions in law firms. All of this driven by that rise in information technology, client expectations, and the growth of a whole wealth of sophisticated intermediaries. This has changed the way in which we think about what we do. Again, we used to be in control of what professionalism meant. We decided who could practice law. We decided how law could be practiced, and we decided what the boundary line was between professionalism and the market. All of this is change. The state has become an increasingly important player in determining the size of the legal profession. So in Korea, for example, which had an unbelievably restrictive bar and how many, the state just came in and said, that's not enough lawyers for us. You will now have 5 times the number of lawyers admitted to the bar than you had before. Governments, in terms of their regulatory capacity, that UK legal reform that I'm talking about was driven by a government-sponsored commission, and the head of it is a non-lawyer who now sits on top of the regulation of the bar and the solicitors and all the other affiliated professionals. But clients have probably had the most effect. They say, we decide what is professional legal services, how much of it we want, how many people we want to work for it on how long. And not surprisingly, again, the lawyers respond by adopting market practices. All of this is happening in an increasingly complicated global environment in which all of the traditional restrictions on language, on legal doctrine, on culture, on even face-to-face personal service have been broken apart, right? None of these things are as constraining as they once were. Having said that, there still is no global government. There still is no global legal order. There isn't even a global language, much as we Americans like to think it is our own. And while technology allows distant relationships, part of the reason why I get on those airplanes is because there's nothing that substitutes for face-to-face interaction. So what do we have? We have a complex mix of the global and the local. I didn't make up this word, globalization. You just smush them both together, but you get the basic idea. And it's about to get even more complicated, because we used to at least be able to say, yeah, but they have to come to us if they really want the real deal, because this is where the economic power is. Even before the crash, many people would have argued that had moved to London. But now the question is, how far east or south is it going to go, right? Is it Shanghai? Is it Sao Paulo? Is it Mumbai? All of the above, many other potential financial centers. And it's not just capital, it's labor. So governments are investing heavily in innovation policy, particularly around law. David Trubeck, who's working with us in this project on globalization, lawyers, and emerging economies, is on his way to Brazil right now, where the government has sponsored a conference to look at legal innovation and its role in the development of the economy, and they've invited the 3 other most important nations they think should be there: China, India, Russia. At this point, I like to pause and say, guess who isn't coming to dinner? Okay? That says something, that the fastest growing economies in the world are benchmarking themselves against each other and not necessarily just against the West. And increasingly, this legal innovation is around the production of lawyers and around legal education. So, as Bill Alford knows, and this was part of the reason we had this conference, is there's been a huge investment in legal education around the world, with new law schools in places like India and China and Japan and Korea, or important private law schools springing up in places like Brazil and Germany. Many of these are adopting the so-called American model, meaning it's a postgraduate model of legal education, unlike the undergraduate model where things traditionally were. And increasingly, we're seeing the rise of so-called global law schools. We had Raj Kumar, the dean of the Jindal Global Law School, our graduate. But we also have the Peking School of Transnational Law, whose dean is Jeffrey Lehman. Here's another hint, he's not Chinese. But where the classes are taught entirely in English, where the subject matter is mostly transnational and common law, and which is seeking to become the first law school outside of the United States to receive ABA accreditation. And the president of the ABA, who was at our conference, this was top of their mind. And I predict that it will probably happen. I said we're going to have these new organizational forms, which they're pioneering in the UK, and don't think they're going to stay there because of things like GATS and technology and other forms of regional trade agreements. If they happen there, it's going to be difficult to keep them out of here as law firms and other forms of practice globalize. All right, so what does all this mean for what we're doing? Well, here's the good news. Complexity increases demand. And there's going to be an increased demand for what lawyers do. Bob Clark wrote a very important article when he was dean talking about how actually we need more lawyers, not less, because the world is getting complicated, more and more complicated, and there's a lot of truth in that. Here's the bad news. There's a lot of people who are trying to get this work, and many of them are not, quote, lawyers, or not legal services organizations. The competition among various kinds of professions and professional service firms is becoming increasingly intense. Moreover, technology will reduce the need for what my friend Richard Susskind calls bespoke legal services, handcrafted, sort of like this beautiful suit, and instead, process-based, packaged, technological-based solutions which will reduce the need for at least some kinds of legal labor. Think legal process outsourcing, which is now becoming very important. Think e-discovery, think electronic hot docs. You could go on and on. If my friends from the Berkman Center were here, they're studying all of these things. And we're going to see an increasingly mobile workforce, some looking for new opportunities, some having to be mobile as other opportunities that they are in are shifting. Well, that raises a bunch of challenges for us, right? Do we try to prepare people for increasingly specialized careers, or do we try to make them generalists that will allow them to move? Will we concentrate education more and more things to learn while they're in law school, or will we try to have experience-based learning and learning as they're on the job? Do we rely on the professional academics who've increasingly staffed law schools, or do we turn to professionals who know much more about what's happening in the real world? Is the purpose to socialize them into the new world, or is it to challenge that new world? Are we trying to develop a set of new core competencies, or is it exactly the opposite of that, a set of a sort of eclecticism that allows them to think like a lawyer, whatever kind of lawyer it turns out they may end up being? Are we training lawyers, or are we training leaders? Should we embrace the market, fight it, or try to lead it? Well, because my dean is Martha Minow, the answer, of course, is all of the above. But, both and. But how do we do that? And it's not just important for us. It's important for society. Law and lawyers has always been closely linked to sovereignty and legitimacy, however that is defined. Whether it's a sort of pluralist democracy like ours, or a parliamentary system, or even in countries that we think of as not embodying these issues like China. This is a key issue in China, and I'll come back to that in just a second. And lawyers have played and are playing and will play a key role in the development of the modern state. So Hakeem Lakhdar, who has joined us here last year, spent the last few years working on ABA rule of law initiatives. There are millions of dollars being spent around the world to promote the rule of law by the State Department, by private organizations, and not just here in the by people here in the United States. Issues of access to justice are on the front of the agenda. When we talked about India, every time people want to talk about large law firms, people say, but most Indians can't afford any legal services. But of course, the same could be true right here in the United States. And lawyers have played traditionally important leadership roles, particularly here in the United States and in the West, but this is true also in many other countries around the world. So, we're left with a challenge, and I want to kind of spend the last few minutes talking about this. Because I'm an academic, I have to give it a famous, funny, academic-sounding name. I call it the challenge of the paradox of professional distinctiveness. What do I mean by that? I've just said that lawyers around the world must respond to all of these changes in the global marketplace. But if they just become agents of globalization, if all we do is respond to these challenges, then the question will be, why should lawyers be entitled to any particular autonomy or any understanding of their own distinctiveness? And this is a serious challenge because norms of craft, public service, independence, commitment to the rule of law have been central to the identity and the prestige and the power of legal professions and the attractiveness of it of a career for the best and the brightest, like the students in the back of the room here. So the loss of these things threatens the recruitment of talent, which in a human capital environment is a very serious problem. It makes us much more easily replaced by other people who can claim to have the kind of expertise that we say, like doing transactional deals, that they might be able to do as well or better than us. And it means that any idea, not of self-regulation, which Andy Kaufman has taught me long ago, lawyers don't have in this country, but even judicial regulation or independence of the legal profession is challenged. Now, this leads to the Triantis challenge. He's looking, because right here in this very room, George Triantis gave a brilliant chair lecture on many of these themes in which he said, is there anything distinctive about corporate lawyers? And when he heard me give a version of this talk in our executive ed class, he said, oh, all that stuff about professionalism is nice, he said, but in his nice way. You know, he's Canadian, so he says it really nice as he's sticking the knife in it, turning. He says, you know, I wonder if 50 years from now, people will just look at this talk as some quaint anachronism, you know? To which I said, look, if anybody's looking at it 50 years from now, I'm already ahead, okay? Especially if I could look at it with them. Look, this is no idle threat. If you look at what happened to engineers and architects, I'm actually writing a paper with somebody about what happened to the architecture profession. Those professions have largely been absorbed inside corporate hierarchies and commodified in ways in which much of their independent status has been eliminated. And anybody who talks to architects and engineers know this is true. The forces that produce that, for those other professions, skyrocketing costs, internal expertise developed by sophisticated clients, disaggregation along supply chains, alternative providers, all these things are happening here. So the question George is asking is, as the state and the market become more powerful, are they likely to squeeze out professionalism? It's a real question. So I don't actually have a great answer to this, but, you know, I mean, it would be a depressing lecture if I said, he's right, let's all go home. Here are 5 things that might make it more difficult for this to happen to us, or at least could mitigate it. The first is history. We've been at this a long time. Anybody who came to the Desilets and Garth faculty talk or has read any of their work, as Yves Desilets would say, I wish I could say it in the French, to which he says it so beautifully, you know, lawyers have been double agents for at least since the 14th century, maybe earlier, meaning they've been playing an intermediary role between the state and the market, between the global and the local. This is not new. We have a lot of experience, and more importantly, we have what Mark Rowe taught me about many years ago in a terrific article. We have path dependence, that we're in those positions, and people are used to being having us in those positions. It's also what draws a lot of people into the profession. This is something that I said before. People go into law as opposed to going to business school because they think law has some connection to a public profession. Now, I realize this can change about expectations. It probably has been changing as, you know, the financial parts of law have become more emphasized. But here's a fact that comes out of our After the JD research, and this is true also in our research that we've done on Harvard Law School graduates. It turns out to be more true of women than it does of men. That women are more likely to enter law not as a substitute for investment banking, but as a substitute for going into public service or journalism or other careers in which also have a kind of connection to larger public purposes. As law becomes an increasingly feminized profession, there is hope that people will want to hold on to this. And this is particularly true because, of course, it's not just law that's becoming increasingly feminized, but the legal professoriate is as well, and other positions of power and influence. Now, I have a whole separate lecture we could give on why it's not as fast as it should be. But the fact of the matter is that the demographics of the people moving into law may provide some bulwark. But this, I think, is more important because whatever we do in law school, it's about what happens in the marketplace that's really going to drive this change. But clients also need the legitimacy of lawyers who are themselves legitimate, meaning that part of the reason that clients turn to lawyers is exactly because they need the legitimacy that comes from the idea that lawyers are independent and have some commitment to the public good that makes it different than turning to your public relations specialist. I think the biggest mistake BP made was putting Tony Hayward out there, and it's not just that he's, you know, looks like the frat boy English public school kid you love to hate, but it's also because he had zero credibility. When Merck got in trouble with Vioxx, he put its general counsel out there, who was very credible and who did a lot to help move the company's agenda forward, right? Companies need legitimacy, and that's increasingly the case as the companies themselves, quote, professionalize, as the management profession tries to professionalize and bring ethics in. And after this crash, this is the major theme that business school academics are talking about. Ask our new dean at Harvard Business School. That's, in fact, I wager, why he is the new dean at Harvard Business School, because he had been working on these issues for a long time. But it's also that the business elite is also overlapping with the legal elite. So here's another thing. Harvard Business School has created more CEOs than any other educational institution. You know what educational institution has created the second most CEOs? Harvard Law School. 26% of Harvard Law School graduates, according to our study, are not practicing law in positions in business and in government, in non-law positions. Business is professionalizing. And the intermediary point for business interfacing with law is often in-house legal counsel, who are themselves have a stake in the legitimacy and independence of the profession. As Rob Rosen taught us in his study of in-house counsel, the big move in in-house counsel has been to try to become more seen as independent. To do that, they are investing in professional independence as a kind of career-enhancing move. The state also has an interest in keeping lawyers independent because it's increasingly turning to gatekeeper regulation. And that certainly was the case after the crisis before last. That was Enron, roughly speaking, and is likely to be true in this new Financial Services Reform Act, using lawyers and other professionals to act as watchdogs over corporate action. This may not be good for lawyers' independence in one way from the state, but it's quite good for lawyers' independence to public norms in another way because it provides real sanctioning that stands behind it. And finally, global networks are pushing professionalism. So when I went to speak at the Shanghai Bar Association, the lawyers who are in those Chinese law firms want to be seen as legitimate members of a legal profession. In order to do that, they need at least the trappings of legitimacy that are the hallmarks of the legal professions they want to join. Chinese law firms and Brazilian law firms and Indian law firms are developing pro bono policies. They're developing, they're supporting rule of law initiatives, in part because rule of law initiatives support lawyers and the importance of lawyers in the state. So, is this a guarantee that we won't turn into the engineers or architects of the future? No. But it does mean that context counts, as both Martha and I have argued on many an occasion, and that there are things that might make this process work differently here, particularly if we pay attention. So, coming back to law school. You know, whether the world is changing or not, legal education is changing and it needs to change. At the conference, we had 120 people, produced 30 concrete proposals for legal education reform all around the world. We need to be a part of this process, and thanks to Dean Minow, I hope we'll be able to lead this process. We need to create education that is more multidisciplinary, not just interdisciplinary, that is more interactive, not just in a pedagogical sense, but also with the world, and that is outward-facing, both within the university and to the profession and beyond. To do that, it's got to be based on a strong empirical foundation of real research about the world and embedded into a process of lifelong learning. That's the cradle-to-grave idea that Martha suggested I'm pushing, right? That ties law schools together with what's happening in professional development in law firms and government to what clients are seeking so that lawyers understand they're part of a lifelong learning process. Now, if all this sounds suspiciously like a plug for the work that we do at the program in the legal profession, it is, but when else am I going to do this at my chair lecture and with my mother in the room? Thank you very much. Thank you, thank you. Thank you. Yeah, sure. So I don't know if anybody has questions. Brian's question is, when do we go home? Soon, but though it has to, Dean Minow.
It's a very compelling story, and I am scared but also encouraged. Just one question that goes in a piece of it, but it's emblematic of the kind of question that I think might be asked. Some of the trends that you describe, I wonder if it can be disaggregated. And therefore, if the responses can or should be disaggregated. So just as an example, the idea of the unbundling of legal services, does that necessarily go with the loss of autonomy?
No, I think so all of these things create both challenges and opportunities, right? So one thing about unbundling and outsourcing and global supply chains, which people often look at as a negative thing of taking our jobs, but actually if we look at it throughout the economy, one of the things it does is provide cheaper products that allow people to do things that they wouldn't be able to do. But also in the law firm context, you could imagine that some of the work that our students hate the most when they go to law firms, like, answering interrogatories and document requests, are gonna be less common. Now, we also have to recognize there might be fewer of them that get hired to do better work, but overall that might be better than a highly leveraged system that we have had, in which we just brought in legions of people, threw them at work, most of which we knew they wouldn't like, and just wait for them to leave. Which is sort of like the old model. I always say the problem with the old law firm business model was not that it was a business. It was just their business model was, roughly speaking, 19th century sweatshop capitalism. Bring them in, grind them up, throw them away, But that was a model. So, look at the high-tech sector. Those are some of the most exciting jobs in the world, and they are subject to every single one of these things. So, no, it doesn't necessarily mean loss of autonomy or loss of quality work, but we better pay attention to it so that people know how to negotiate that. Betsy, and then Todd.
So most of this is about can we, and it's, we might like to, but should we? Is there something unique that lawyers offer?
So I guess I want to answer this on a couple of levels. And again, George, thinking with George is always so helpful on these things. And so the first thing I said to him when he said, 50 years from now, will people just think this is quaint? Is I said, George, the fact of the matter is somebody has to play this role, right? That is, somebody actually has to, in a market economy, has to restrain the worst impulses of the marketplace. Somebody has to look out for the public framework and the structure. Somebody has to make sure that people have at least some basic access to the system in a way that at least to provide the basic goods the system can provide, let alone the things that it could provide. So society needs somebody to play this role. And then, we've been playing it for a long time. Now, we haven't been playing it all that well. And quite frankly, on the should survive, one thing that I think shouldn't survive is our monopoly over being able to provide these services. So, again, this is what's happening in the UK. The impetus for the UK reforms, which people now mostly talk about, the publicly traded law firms and sort of the fancy things. But it really was, how can we provide better, more efficient, cheaper services to individuals? And the model they had is what they called Tesco law. Tesco being the largest supermarket chain in the UK. And the idea is, under these reforms, you could go and pick up your fruits and vegetables, and you could go and get a name change, and it'd be right there. And maybe it would be delivered with the efficiency that, goods are moved through a supermarket supply chain, and that would be a good thing. So I don't think we should be entitled to survive simply because we were there first. But I also think that there are some things about our traditions, about the education we provide, about the fact that we have seen ourselves situated between the market and the state, between the global and the local, that gives us important resources that, if we use them correctly, will mean that not only should we survive, but people would want us to survive. Todd, my cooking partner, I have to call him.
At the conference over the weekend, a lot of people were talking about legal education relating to practice. But the people talked about that, the people were talking about that from Cumberland Law School. We're talking about it very differently from people from Villanova. The people from Villanova were talking about it very differently from the people at Harvard. Does cradle-to-grave legal education mean that we have to visualize a certain segment of future careers as the careers that our students are going to follow, and no longer purport to be the general law school? And is that true of legal education in general and specifically of Harvard Law School?
So, one of the things that makes studying lawyers endlessly fascinating and complex is that we have a highly segmented legal market and legal profession. In fact, I started arguing almost 25 years ago when I first got here that it isn't just to say the legal profession is very, very misleading. There are many legal professions. But in a piece, actually, it's funny, they're doing a book in which a bunch of people are writing, kind of inspired by a piece I wrote 20 years ago called Legal Realism for Lawyers, in which I argued for this kind of context-based understanding of legal practice. But then as I was sort of writing this kind of forward for it, but the problem is we don't want to be segmented either, because we know that people are increasingly mobile, right? So after the JD thing, when we first surveyed them in 2003, they'd only been out 3 years, something like 60 or 70% of them had already changed jobs. And by the time we surveyed them in 2008, all of them had changed jobs. The average number of job changes was like 2.8. And many people were changing sectors, not just jobs. In other words, they weren't just going from one large law firm to another. They were going to smaller law firms. They were going into government or out of government. There's a huge amount of mobility. So we need to be training people how to be mobile, okay? Now, I do think we owe them a realistic assessment of where people like them tend to go. And actually, it's interesting, the ABA, actually, again, we had all these ABA types. It was really quite fascinating. And one of the things they're very focused on is trying to get more accountability and transparency in law schools about where people go and what the real trade-offs or cost of a legal education is. And the fact of the matter is, almost nobody knows the answer to this question, because the most they know is where people are, at graduation or maybe 3 or 6 months out, and they know almost nothing after that. So I would say, one, I think law schools have an obligation to study our own graduates and their career paths. The past isn't necessarily the future, but the past is at least one indication of what kinds of possible futures there are out there. Second, I think that law schools, that we should be studying people who change. That is, we should pay particular attention to the people who move and how they move and why they move and where they move, because that actually is going to be more representative of the future. But finally, Todd, I think there is no one-size-fits-all for any of this. And I think, in a way, what's wrong with, I mean, there are many things. One of the things wrong with legal education has exactly been the enforcement of a unitary model about what legal education has to look like. And some of those proposals, as you know, and the reason why I wanted to have the ABA people there, require a change in whether it's accreditation policy or other kinds of policies that would allow more distance learning, that would allow, you know, shorter learning, you know, a 2-year degree, you know, not so much to say that we should become a series of specialized professions, but just to recognize that in this tremendous diversity of what lawyers do, we need more diversity in the way in which we train them. Andy.
So as we tremble along the edge of the new future and changes in the world and changes in the legal profession and legal education, if you take yourself back to the end of World War II, look at the period between then and now, the changes in the world are vast, and the changes in the legal profession are vast. And as you look at the relationship between them, who led the changes in the legal profession? What kind of job did we do? Did it happen incrementally or unconsciously? And what grade would you give each of the elements?
Can I use the new grading system? You know, I think the biggest, you know, I always hesitate to say the biggest because there's so many things. But one big problem we made was we let those changes happen in the last 50 years happen unselfconsciously and unreflectively. And it's because before there was an Andy Kaufman, there wasn't anybody studying the legal profession at all. And for years, you were a lonely warrior, not just at this law school, but anywhere, right? And the studying of the legal profession, to the extent it was being done by people who were disconnected from the profession. I mean, it was done by historians and sociologists. Much of it is very valuable, just like much of the work being done by economists now is very valuable. But they don't, so to speak, have a dog in the fight, right? They don't have a stake in the development of lawyers. And that law schools pretty much left the profession alone. The view was, we'll teach them how to think like a lawyer, and then we'll give them to you, and you're responsible for them, and just send enough of them back to make enough money to build our buildings. And that was sort of the deal. That was all we really, that deal was a disaster. And it was a disaster for both sides. It was a disaster for us in terms of how we were preparing our students, but it was a disaster for professionals who were then confronted with immense changes and were searching for how to think about those, how to process those, how to find yourself. You went to law school to be, roughly speaking, smarter than Oliver Wendell Holmes, and now you're running a multi-billion-dollar global business. What's up with that? You know, and what happened was they started going to the business school to teach them how to do those things that they suddenly found themselves doing. And, you know, we could say about what kind of education, excuse me, they got there, but they should have been getting it from us. And so at least if we can commit ourselves to say, we're going to be a part of the process and not just criticize from the outside. That's the other thing we did, was we just said, it's terrible, it's becoming mercenary, you know, the jobs are terrible. Aren't we lucky we don't have to be there? Except for the fact that everybody who we're teaching, roughly speaking, 90% of them are at least going to go there for some period of time. We have an obligation to be part of the solution, because I'm a 60s guy, and if you're not part of the solution, you're part of the problem. Bill?
David, thanks. This is a Great. It's two self-interesting questions. So the law professoriate, I mean, there are all kinds of different models, right? Latin America, people are part-time. Here, increasingly moving toward having multiple degrees and not a lot of engagement. What's the Wilkins vision of what the future of the law professoriate will be, should be, or would likely to be?
So I think that, first of all, again, just as in legal practice, there are going to be multiple models. But even more than that, I think we're going to have multiple kinds of people with different kinds of credentials and different orientations that will be part of a functioning faculty. Now, many places are constrained, so they're part-time in Latin America, mostly because the public universities don't pay any money, and Raj Kabar was here and said that's a huge problem in India, which is why he said he started a private law school that has issues of its own, but at least he said, excuse me, we could pay our faculty 3 times. We pay our junior people 3 times what tenured people make in even the best of the national universities, right? A huge change. For those of us who have at least some resources, and Martha, I'm not overstating it, some resources, I think that, you know, again, we forced everything into a unitary model in which everyone who was on the law school campus either had to be exactly like us or wanting to be us, you know. I think we're going to need multiple different kinds of people. Because, for example, Martha has a wonderful initiative that she's trying to start on kind of living well as a law student, I think we're calling it. And it's about not just career planning, but figuring out how to live your life and balance and mentorship and getting yourself in kind of relationships. Well, the fact of the matter, if we're going to do this well, you know, yeah, you're laughing, John. There are not many of our wonderful colleagues who have a lot of training and experience to do this, right? And so I'm trying to be gentle here. So we're going to need different kinds of people. On the other hand, we need the top scholars who are thinking critically and in a creative and multidisciplinary way. We need theoretical scholarship, right? Because it's a time in which theoretical paradigms are being remade, right? We should also ask them questions about it from the real world, but they should also ask those of us who work at a more closer level to the ground about how what kind of vision, what kind of world are we imagining? What kind of ideas are we promoting? So I tell my students that I think it's one of the most exciting times to think about being involved in education, particularly legal education. Because if you look, there are just going to be many more opportunities. Legal education is actually a growth industry around the world. It's not just happening in law schools, it's happening inside organizations, it's happening through private providers as well as public providers. It's happening globally. My favorite example of this is, you know, there's this whole Indian outsourcing industry. One of the big complaints or worries about its expansion is that the Indian lawyers don't have a sufficient understanding of U.S. ethics, you know, sort of confidentiality or rules. So when they're looking at documents, they may not appreciate the finer points of U.S. professional responsibility law, to which I first always say, and you think, you know, bleary-eyed second-year associates in law firms do, but let's pass over that. So what did they do? And the law schools don't teach anything about this. So now there are private providers. There's a company called Rainmaker, which now offers certificates, you couldn't make this stuff up, in LPO, working in an LPO, and they are hiring U.S. lawyers to give a course in U.S. professional responsibility law to Indian lawyers. Who would have imagined, right? Mostly these are people who had been in practice, either older lawyers, some, or second careers. Look, I think it's an exciting time to think about these issues. It's actually a much more exciting time to think about them and a scary time to live them in some ways. But I think, like all things, opportunity is there. We just have to figure out how to try to understand it and to grasp it and to help our students make their way and help to remake the world in which we're living. That's why I have the greatest job in the world. Okay, one more. Yes, please.
What advice would you give to current law students who will be graduating and entering this new globalized legal profession, and how might they start preparing now to compete with the Indian lawyer or the Brazilian lawyer or even the non-lawyer?
I think, first of all, the very fact you recognize that this is an important reality already puts you ahead, right? The fact that you know that you're operating in a global environment that is increasingly fluid. The second thing I would do is to take every advantage you can to learn about what's happening in the world. Again, thanks to Dean Minow's amazing work before she was dean, we now have international law as something that every student at least has an introduction to. Build on that. But build on it not just here in the law school, but look at what's happening around the university, and build on it not just in the classroom. Actually, it was interesting. On one of the panels, I forget which it was, where somebody was talking about globalization, they said, you know, the most important thing is not what you learn in class, although learning in class is very important. It's the relationships you make. You know, actually in this project John and I work on, we have this great thing on how corporations purchase legal services, and John, who's much more tech savvy than me, dumped all our interviews into this big program called Wordle, and it was trying to understand what's the most important thing about how corporations purchase legal services, and it shows you the bigger the word, the more important or more frequently it's used. And the word relationship was this big giant word, right? And then, as I always point out, the word smart is really tiny little in a corner. Okay, it's about relationships. So here's one thing. Every year, we have over 200 of the most amazing, talented, accomplished students from around the world who are right here with us at Harvard Law School. Take the time to go to the Lewis Center, to, you know, invite somebody over for lunch, help them set up a bank account, take them home for Thanksgiving dinner. Those relationships will be invaluable to you because you can ask them, what's going on over there? How are people thinking about things? Because it's not just competition, it's potential clients, it's potential collaborators, it's allies, right? Take advantage of building relationships, right? As you build your knowledge, build your relationships. And plus, the LLMs have the best parties in the school, without question. All right. Thank you all for your patience. Thank you very much. Thank you. Yeah, we'll get in this. We'll like it.
Leave it to David to get us to laugh and smile while he's telling us that the world is going to end. But no, that was just superb in every possible way, including the emphasis at the end on relationships. David, you make the lives of so many people better at this institution. Everything has been done that needs to be done except two things. One, drinking, which is about to happen in David's honor. But before that,
So, Brian, would you like to come sit in my chair? I won't say anything about how things have improved in recent years, but the last chair I got, Bob gave me like a folding director's chair.
everyone come drink, toast David.